All right, so let's start with Clark versus Clark, and I see I've got a Cheyenne Clark in the waiting room.
Cheyenne Clark, and then Zachary Clark is the plaintiff in this matter.
All right, let me see. Hey, and there's McFallahey too for that other case. So we'll take care of Clark, and there's Zachary Clark. We'll get them both connected. Okay, Mr. Clark, can you hear me? Mr. Clark?
Looks like the signal was weak, got disconnected, and now he's.
Mr. Clark, can you hear me now? It's showing we're connected, but obviously he's not hearing me. Do you happen to have his phone number? Let me try that. Hopefully he'll answer his phone.
My experience is that usually when I call them, it bounces them out of their app.
Oh, okay. It says it's connecting to audio. Mr. Clark, can you hear me now? Yeah, he's just having trouble making a connection. What's the phone number?
I have 945 6476.
Oh, we might be connected. He's muted at the moment. Let's try that.
Zach, unmute your phone.
Can you hear me now?
Oh, yes, sir. Okay. Mr. Clark, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name for the record.
Zachary Michael Clark.
Go ahead, Mr. Whiting.
Thank you, Your Honor. Mr. Clark, you signed allegations and a complaint for divorce in starting this matter, correct?
Yes.
Were the allegations true at the time you signed them?
Yes.
Do the allegations remain true today?
Yes.
In the proposed settlement and the proposed divorce, were all the children born during this marriage under the age of 18 listed and provided for?
Yes.
To the best of your knowledge, is your wife currently pregnant?
No.
Are you reasonably certain that this marriage cannot be preserved under the circumstances?
Yes.
You have gone over a proposed settlement in this matter, have you not?
Yes.
Do you understand the terms of that proposed settlement?
Yes.
Have you voluntarily approved this settlement and you will be approving a judgment of divorce?
Yes.
And one final question, are you fully and completely satisfied with the representation that I have provided you and that of my office?
Yes.
Your Honor, I believe I've established a factual foundation. A judgment has been prepared. It is being emailed to the parties this afternoon for their review and approval. We would ask that the court hold this on for a status conference, judgment due August 4th, which is the trial date in this matter.
All right, so Ms. Clark, let me ask you, can you confirm that you are not pregnant today?
Yes.
And all right, obviously you haven't seen the final form of the judgment of divorce, but you're generally familiar with what you're expecting to be in it.
Yes.
And do you find what you're expecting to be in it to be a fair and equitable resolution and in the best interest of your children?
Yes.
Very well. I do find there's been a breakdown in the marriage to the extent the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. I will sign a consent judgment of divorce upon presentment. We have an August 4 trial date. We will turn that into a status conference date. How's that?
Thank you, Your Honor.
As long as you get that judgment to me before then, there's no need to show up.
Thank you, Your Honor.
You're welcome. Have a good day, folks.
You too. Bye.
Thank you, Your Honor. Have a good afternoon. I'm not hanging around for the Jonas matter. I believe
Oh, okay.
he will be entering proofs and submitting a judgment that already has my signature and that of my client.
Fair enough.
Thank you. Have a good week.
Yep, have a good day. Good morning, Mr. Fallahy.
Excuse me. Good morning, Your Honor.
And I'm looking, I believe, for Nicholas Jonas. Is that right?
It's Nikki. Nicola is her legal name.
Nicola. Okay, there is no S on the end of that.
That's
I bet
correct.
she's heard that before, though. Nicola. I've got 2 Galaxy phones in there. I have no idea which one might be your client. I'm just going to try.
Thank you.
Let me know if you recognize her. Is that she?
I believe so. Hard to see from here.
Looks like we've got a connection. What is your name, ma'am?
I'm Nicola Jonas.
Okay, we got the right one. All right. Would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name.
Nicola Lynn Jonas.
You can put your hand down. Go ahead, Mr. Fallahy.
Thank you, Your Honor. Nikki, can you hear me okay?
Yes.
All right. I know we've done this pro confesso hearing before, but we waited a bit too long to get the paperwork in, so we need to do it again. So I just have a few questions for you, okay?
Okay.
Do you remember signing the complaint for divorce in this case?
Yes.
Were the allegations in the complaint true when you signed it?
Yes.
They remain true today?
Yes.
Are you pregnant at this time?
No.
Now, you and your husband, Kevin, have reached an agreement relative to the division of all of your property. Is that correct?
Yes.
And both you and he, as well as your attorneys, have signed that judgment. Is that correct?
Yes.
And do you feel that it's fair under the circumstances?
Yes.
Is it your opinion that there's any chance for reconciliation at this point between yourself and Kevin Jonas?
No.
Are you asking the court then to sign the proposed judgment of divorce as well as the uniform child support order that were previously submitted to the court?
Yes.
Thank you,
Yes.
Nikki. I don't have any further questions.
Okay. Thank you.
Very well. I'm satisfied based on the proofs that there's been a breakdown in the marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage could be preserved. I have signed your judgment and your uniform support order, Mr. Fallahy, and we'll make sure we get these right back to you.
Thank you very much, Your Honor.
And that was your only matter this morning?
That's correct, Judge, yes.
Okay. Thank you. That concludes our hearing. Have a good day.
Thank you,
Okay,
Judge.
thank
Thanks,
you,
Nikki.
All right. Thank you.
Good morning, Your Honor.
Good morning, Ms. Girding. How are you?
Pretty good. How have you been?
The only complaint I have is about my hip, and it has taken forever to get it fixed, thanks to our pandemic. But I do have a surgery date coming up, so I'm hopeful.
I'm hopeful too.
Once that's resolved, I won't have any more complaints.
I totally understand.
And if you believe that,
We can be hopeful,
Is
Your
this-
Honor.
is this your client that's coming into view here?
Yes, that is my client, Miss Moore.
Okay, let's get her to unmute her phone.
Is that
Okay.
better?
You can hear me.
Yeah, we can hear you now.
Okay.
So, this is a pretrial. Do you know if Mr. Stump has found substitute counsel?
Well, Your Honor, I can give you good news. He wasn't going to look for a new counsel since Mr. Ashley had passed. We do have a signed consent judgment that has been already sent over to the FOC for approval, but I haven't got the approval back yet to present to you.
Oh, so I just need to take some proofs today.
Correct.
Okay, Ms. Moore, would you raise your right hand, please?
Yep.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name, and you can put your hand down.
Trisha Lynn Moore.
Go ahead, Ms. Girding.
Yes, good morning. Catherine Girding appearing on behalf of Ms. Moore. Ms. Moore, at the time the complaint for divorce was filed, had you been a resident in Jackson County for 10 days and a resident in the state of Michigan for at least 180 consecutive days?
Yes.
Were the allegations in the complaint true at the time the complaint was filed?
I'm sorry?
Were the allegations in the complaint true when the complaint was filed?
Yes.
And those allegations still remain true today?
Yes.
The allegations are that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that they can be repaired. Is that true?
Correct.
If Judge LaFlamme did not grant the judgment of divorce today, are there any circumstances where you would live together with Cody as a married couple?
No.
There's no possibility of reconciliation, correct?
No.
To the best of your knowledge, are you currently pregnant?
No.
2 minor children were born of this marriage, correct?
Correct.
And that would be Blaze Stump, born April 1st, 2015, and Odin Moore, born March 30th, 2018, correct?
Correct.
We did come to a complete settlement on all outstanding issues of property, support, custody, parenting time, etc., correct?
Correct.
And you do understand that it is final and a binding agreement as to all property issues. And only issues the court can review in the future are custody, support, and parenting time for the minor children, correct?
Correct.
And you've had the opportunity to review the judgment of divorce and all its support provisions, including the property division and the waiver of spousal support, correct?
Correct.
And you understand that both you and Cody are waiving spousal support, which means that in the future, you cannot come back to this court and ask for that to be reviewed.
Correct.
Do you believe that the judgment and its terms are fair and equitable?
I do.
And you do understand you had a right to trial in this case, and at trial, Judge LaFlamme could have ruled more favorably, less favorably, or substantially similar to the ultimate settlement of this case?
Correct.
And you're asking him to enter this judgment of divorce and waive your right to trial?
Yes.
Also, you have seen the document that Cody signed. Could you verify that that was his original signature on that document?
It was.
Are you satisfied with the efforts of your attorney in this matter?
Yes.
Do you have any questions for me or Your Honor?
No.
Your Honor, do you have any questions for my client?
Just one. Can you confirm that you did not have any children during this marriage that are not Mr. Stump's children?
I can.
Wonderful. Believe it or not, that has happened a few times.
I believe
And
it.
if I don't ask that question, within a very short order, people are back in here saying, well, I didn't think you meant about that one. So anyway, all right, I am satisfied based on the proofs that there's been a breakdown in this marriage to the extent the objects of matrimony have been destroyed. There remains no reasonable likelihood the marriage can be preserved. As soon as I receive that approved consent judgment of divorce, I'll sign it and we'll make sure we get it back to you, Ms. Girding.
Thank you very much, Your Honor. You have a wonderful day.
Thank you, you too.
Thank you.
Good luck to you, ma'am.
Thank you.
Okay, Gail versus Gail. So,
Morning.
this is a date and time set for your pretrial. And what we do at a pretrial is figure out whether it's necessary to have a trial. In a divorce with minor children, the issues that would require a trial typically are division of property, what's going to happen with real estate, division of debts, custody, parenting time, child support, all of those things. Is there anything in dispute between the two of you?
No.
So you're prepared to move forward with a judgment of divorce today?
Yes.
Yes.
I don't suppose you brought a proposed judgment of divorce with you?
We have no property.
Yeah, we don't have any.
All right, well, there still has to be a judgment for this to happen. I'll tell you what I'm gonna do. I'm gonna fill one out for you.
Okay.
So initially, ma'am, I gotta take some proofs. Let's see, you're the plaintiff, is that right?
Yeah.
Would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name.
Jessica Lane Gale.
Ms. Gale, you filed a complaint for divorce back in December of last year. Was everything in that complaint true at the time that you filed it?
Yes.
And does it remain true today?
Yes.
It appears from the temporary order that was entered that there are 3 living minor child born or adopted during your marriage to Mr. Gale,
Yes.
Aubriana, Ashlyn, and Jesse.
Yes.
Did you have any other children during this marriage?
Yes, I did.
There-
He's not listed on
Who is that child's father?
it. Robert Lee Hayes II.
Okay. And sir, you understand that that is not your child?
Yes, sir.
Legally, under the law, it is your child. You are the legal father to that child unless I take care of that in this proceeding. And I can take care of that this morning. So ma'am, how old is that child?
He's 7.
And what is his name?
Robert Lee Hayes III.
All right. And is the biological father of that child involved in his life at all?
Yes.
Prior to today, you haven't taken any steps to have Mr. Gale determined not to be the father of that child, is that right?
Well, to make a long story short, okay, so little Rob was born and I had an addiction issue. I ended up getting sent to prison and a bunch of stuff happened. I had to sign guardianship over to little Rob's stepmom. And she said that she changed it while I was in prison. And I got out in 2016. She said that it was already done.
But you remained married to Mr. Gale throughout that time?
I did.
Well, I don't know what else might have happened. I think it's highly unlikely whatever the guardian said happened. But the only thing that could have happened would be if there were some kind of action taken to terminate both your and Mr. Gale's parental rights to that child. You're not aware that that happened, are you?
No, I had 50-50 custody.
Okay, so, I'm sorry, what's the child's name again?
Robert Lee Hayes II, or Robert Lee Hayes III.
Robert Lee Hayes III. And what's his date of birth?
9/19/2012.
Is there any possibility that Mr. Gale is the biological father of Robert
No.
Hayes?
I was incarcerated.
So he was incarcerated, Mr. Gale was incarcerated at the time Robert was conceived and at the time Robert was born.
Yeah.
Okay. So it is biologically impossible that Mr. Gale is the father of this child.
Right.
Okay, and Mr. Gale, let me just take a little bit of testimony from you. Would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
State your full name.
Joseph Edward Gale.
Do you acknowledge that Robert Lee Hayes III was both conceived and adopted while you were incarcerated? I'm sorry, conceived and born.
Yes, Your
I don't know
Honor.
why I said that. And is there any possibility that you are his biological father?
None at all.
And do you wish this court to determine that you are not the father?
Yes, I do.
All right. So that covers that. I can't make somebody else the father. I can only determine in this case that Mr. Gale is not the father. You folks have a stipulated temporary order for custody, child support, and parenting time. Is that working out okay for you?
Yes.
Yeah.
Would you like me to continue that as a permanent part of the judgment of divorce?
Yes.
Ma'am, are you pregnant today?
No.
Is there any possibility of you and Mr. Gale reconciling? Okay, so that allows me to grant the judgment. Now let me figure out, I'm going to start filling this out. Ma'am, do you still live at 603 Union Street?
I just recently moved. It's 610 Stewart, apartment number 1, 49202.
We can make that change in a circuit court system, but you need to let the friend of the court know whenever your address, oh, you did already. You have to let both know. For some reason, our two systems don't talk to each other.
Yeah.
And Mr. Gale, are you still at 839 East North Street?
No, sir, I moved this week.
Okay.
I live in Addison. I don't know the house address right off the top of my head, so I'll call and update that.
All right, I'll just leave the address blank on this then. Ma'am, do you wish to have your last name changed?
No.
Are either of you seeking spousal support from the other?
No.
No.
Do each of you agree to release any interest you might have as a beneficiary under a life insurance annuity or similar arrangement on the life of the other?
I have, life insurance that's just on me and the kids.
Right, so he's currently not named as a beneficiary on that,
Yeah, he is. Well, he is for the kid, yeah, for the kids,
for the kid's sake.
yeah,
Um,
because they're under 18.
the children can still be named, and somebody who's a parent can take care of that. So is there a specific designation on this policy that says that they're the beneficiaries and he only gets access to that for their benefit?
Yeah.
All right, actually, I've never had anybody tell me that before. I guess what I can do is put a provision that says elsewhere that he's a named beneficiary as a trustee on behalf of the children.
Yeah.
All right, let's do it that way. And sir, do you have any policy or annuity, et cetera, that identifies mom as the beneficiary?
Not currently.
Okay. Are either of you seeking any right in pension or retirement savings of the other?
No.
Have you already divided all your personal property?
Yeah.
Yes.
Have you already divided all your debt?
Yeah.
Do either of you own any real estate?
No.
No.
Well, there's a bit of a wrinkle here that I'm not quite sure what to do with. It says that there's an existing support file.
Well, so when we went to the front of the court, because he was paying child support, but when we went down to front of the court, like 4 or 5 months ago? Right around there, we both just decided then that, we were gonna drop the child support and, we were gonna share the kids, and if they needed something, we were both just gonna help.
So you've essentially opted out of friend of the court services.
Yeah, in front of the court.
All right, well, in order to do that, there needs to be a special form in the file. Let me see if I can find it. I'm surprised they didn't insist on that when you went to the front of the court. They should have. Well, it's not letting me connect to the right drive. Usually the only way I can fix that is by rebooting. So I'm going to go into my office computer and find this form so that we can get you folks on your way.
Thank you.
My computer's not letting me on the key drive.
Oh, okay. Do you need me to look?
No, I gotta pull it up and fill it out.
All right, I'm taking us off the record, Judge.
Turbines today. It's like these big flat. I gotta climb up this ladder, clean everything, the top out. Things I don't. I'll be tied in. Save people in hands. You take a picture and post it online. Me at the top. stay getting the project and the project, something so much bigger, not too good. She don't make it. Back to them. So you get to on rolling through the. December or January,
Oh, wow.
we're talking about putting in another 60. Don't what? They got girls that work there. Not just something that, there's a couple scientists, there's an engineer. But I mean, you can go flat for, sit there, whole site, stop, slow, stop, too slow. Local, it's not a good effort. Call Union Hall, tell them you're interested in working on the Crescent Point project. Like, you know, what projects on there, sticking stuff on there. All over the state. Rubber's the only third largest company in Michigan, so. But the union, you won't necessarily work at the same company, they can put you anything, you work for this. A week. Every other week, so you go back and forth. Or you leave it down. There was one. Purple? You gotta figure out gas like you're gonna spend $60 a gas. Well, past, that water stains. About 3 grand. We'll go back to. Huh? Still only 20 grand.
Okay, Shannon, you can put us back on. Okay, I learned that that support file, the 2012-3244 DS now has a no support order in it. I'm just going to reflect that that's going to govern child support in this matter. Then I don't have to do anything else. Matthew, do you need a signature?
Okay, here's one, yeah.
Come on up. I know who you are, so you're fine. So you're back.
Yeah, my sister-in-law, she's a nurse, so she get tested. She tested negative, so. We should all be good.
Yep.
We should all be good.
I was gonna say, you all, you're all there. I know, I'm ready.
I know, I just took that. He's exhausted.
He-
He's worrying about.
It's so on. It's so on.
We said it was like a 12-hour ordeal because.
Oh, really?
Yeah. I don't even know where he is. Oh.
That's where he always goes every summer, because he doesn't have any cell phone service.
Yeah, that makes sense. You sent an email, though. You sent a couple emails.
Did he send a couple
He
of
did,
them?
yeah.
Okay. Yeah, you're right, he did, because, you're right, he did. I'm surprised he did that.
I know, but I mean, it's just, he's so, he's used to it now, even this. Yeah. I checked emails a couple times. Only when I was sitting around doing nothing.
Right, exactly.
There you go, Matt.
Thank you, Dave.
You're
All right.
welcome.
See you soon. Yeah, I'm sure they were. I'm sure they were. Mhm.
Everything was okay.
Mhm. Yep, we were good. Except that.
Shocker.
Yep.
Thank you.
All right,
See ya.
have a good one.
You too.
It normally doesn't take this long, folks, but you threw me several curves today.
Sorry.
That's okay. Not your fault. All right, let me look at it one more time. All right, I don't know if I made this finding on the record, but I do find that there's been a breakdown in your marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood your marriage can be preserved. I am granting a judgment of divorce. And I'm going to give this back to you. And if you take this downstairs to the clerk's office, they will make you 2 true copies of this. So you can come up and get that. That'll be on the first floor, around the back of the elevators where all the teller windows are.
Okay.
Thank you, sir.
You're welcome. Good luck to you folks.
Thank you.
All right. I need to take a very short break before I call the next matter.
Do I have time to run across the hall?
Yeah.
Sweet. what happened with that settlement conference yesterday? Did you put anything on the record?
We did.
Oh, you did?
Yep, we settled it. Okay, let's.
So everybody was here and whatnot?
Yep. Jan Hamilton, defense attorney, Jan's client, and a insurance adjuster for the defendant.
All right.
Okay, let's see, Citizens Insurance, let's see who's on this. Jennifer Horde. See that firm. So, Mr. Horde, thank you for putting the case number on your screen name. That was very helpful.
You're welcome.
There's so many names on this. I'm trying to figure out who else is here. Katrina Morell?
Yes, she should be the only other individual.
Oh, okay. And you're not expecting any parties?
No.
Okay, counsel, this is a matter of citizen. On your screen name. That was very helpful. Okay, we are on the record now on the matter of Citizens Insurance versus Progressive Michigan. Counsel, could you each state your appearances, please?
Good morning, Your Honor. Jeffrey Horde on behalf of plaintiff citizens.
Counsel, state your appearance, please. Ms. Morell?
I think she's having an issue with her audio, Your Honor.
Just give me a minute.
I hear you now. It's working. We lost her. All right, let me keep my eye in the waiting room and see when she reappears. I'm guessing she must have had trouble hearing me because I could hear her.
She sent me a text message, Your Honor, saying that her audio wasn't working. She couldn't hear us.
Okay. Guys, ask her for her phone number. I'll just dial her in. Actually, if you've got a text message, you probably have her phone number.
I do.
Why don't you give me that?
It is 734-223-5307.
This is Katrina.
Ms. Morell, this is Judge LaFlamme. We see you're having trouble with the Zoom, but if you don't mind, we can do it with you on the telephone. Are you okay with that?
Sure. I was just going to come in on my other computer, but either way, Your Honor.
How are we spelling morale?
Murrel. Okay, and Ms. Morell, this is, well, whose is it? Oh, it's plaintiff's motion, I guess.
Yes, Your Honor.
Correct.
Go ahead.
What we're seeking to compel are two claim notes that discuss a decision why Progressive was not going to rescind the policy. This matter all revolves around a rescission of a policy that then eliminated no-fault PIP coverage for 2 minors involved in an accident where their mother also tragically passed away. These 2 claim notes are discussing the bases for why Progressive doesn't believe it's going to rescind, which is the very issue that we're talking about. These are not discussions, they're not legal strategies. In fact, if they would have not rescinded, we wouldn't even be here. So the 2 claim notes also were partially read into the record at the deposition of another claim rep, and there was no objection to this being read into the record. So there was also a waiver of any privilege that could be asserted. And then I think the big thing here, Your Honor, is that they're objecting to an early on decision not to rescind and why they believe that the facts here are immaterial. But later on, when they do determine to rescind and they put the bases and the facts and the decisions in there, they didn't redact any of those. So they are really here trying to say this early stuff that's bad for us is work product, but the stuff later on that we want to rely on, that's not work product. Clearly, these are just facts that are material to the question at issue, which is this rescission. They're not privileged, and if there was any privilege, it would have been waived because it was disclosed at the deposition without any objection. So what I'm asking for is to compel these 2 claim notes to be produced without any of the redactions.
If you already got the redactions at a deposition, what difference does it make?
I didn't get everything from what I can tell. From the transcript, she read in part of it, and I don't have everything. And the part that she read in, I'm not sure if it's from the claim representative or if it's from the supervisor approving that. And these would be relevant for purposes of trial to put these into evidence as far as the decision that was made early on. And it would also be used for impeachment and other credibility questions of these 2 witnesses.
Okay, understand why you're seeking this. Let me hear the response.
Your Honor, the process that these the claim representatives went through, and which are reflected in these claim notes that plaintiff is seeking, the handling claim representative set forth her thoughts, her recommendations, and what her mindset was, what her opinions were. She sent that to her supervisor, who took a look at those and then set forth her opinions and her thought processes. And then from that point, it was assigned to a new claim rep, and then it went to legal, and then it went to a roundtable, and so all of that information that's in those claim notes really are it's her opinions and her processes to get to where we are today, and under work product, those claim notes are protected. And furthermore, he asked her about it, and she essentially told him what it said. So I don't know what more he needs. He has her testimony.
All right. Well, I'm going to rule that irrespective of whether or not the redacted portions are protected by the work product privilege, that privilege was waived as a result of the disclosure of the information without objection during the deposition. So I'm going to order that unredacted notes be provided to the plaintiff. Mr. Hoard, you prepare that order?
I can, Your Honor. Do we want a time frame, 14 days?
That should be ample. Let's say 14 days from the date of the order.
Okay. I will prepare the order. Thank you, Your Honor.
Okay. Thank you, counsel. Have a good day.
You too.
Thank you.
Let's see, the clerk. Yeah, I don't think anybody's going to be here on Morgan, Wells Fargo versus Morgan. Looks like they've already got a default entered. Well, let's see who's left once I finish. LAFCU. Smith and Johnson, let's try that. Okay, this is the matter of LAFCU versus Hensley. I don't see anybody by the name of Hensley in the waiting room, but I do see a telephone, so I'm going to see who that is.
Thank you, Your Honor.
I just allowed a telephone number into my courtroom, 517-499-3047. Could you identify yourself, please?
Yes, sir. My name is Matt Morgan.
Say that again. I couldn't make it out.
I am so sorry. My name is Matt Morgan. I'm O-R-G-A-N. I'm going to stand by this before I get a better signal.
Matt Morgan. He is on Wells Fargo. Okay, Mr. Morgan, I'm going to put you back in the waiting room because I'm hearing a different case now. I'll get you back in when I call your case, okay?
All right, I'm so sorry. I have a bad signal. If I lose signal, I'll keep dialing in.
Fair enough.
All right, thank you.
Well, what happened?
Looks like you parked him in the waiting room.
Yeah, my screen changed from gallery view, so I thought I'd lost you too. Okay. The only other person I see in the waiting room doesn't have a name associated with your file. So you're here on a motion. I'm sorry, counsel, state your appearance.
Tim Smith, Smith and Johnson attorneys on behalf of plaintiff LAFCU, LAFCU.
All right, and you're here on a motion for possession pending judgment?
I am, Your Honor.
Matter was scheduled, I believe, for 10 a.m. I don't have a defendant either in the waiting room or present in the courtroom. I will grant your motion for possession. Just submit a proposed order and we'll make sure that gets entered in the normal course.
I believe it was submitted at the time of that the complaint was filed. Does your court file reflect a proposed order?
I didn't see it, but let me double check. No, I do not see what the only order was. The order attached to the motion itself was the restraining order and order to appear. That was signed, but I don't have it.
Yeah, I've got one. What is the quickest way to get it to just have my staff contact clerk's office, fax it down?
Or you can email it to Patty Clark. Her email address is on my website.
Yep.
She handles my civil matters. Just email it to her and
Perfect.
I will sign it.
Appreciate your help today, Your Honor.
You're welcome. Have a good day.
You as well, sir.
And what's this other one? Charlotte. Fuck. I have no idea who that is. So we'll find out. State your name, please.
Hi, Charlotte Hack on behalf of Wells Fargo Bank.
Oh, okay. Well, hold on. I've got Mr. Morgan in the waiting room. Let me let him in.
Charlotte
Okay.
Hack.
H-A-A-C-K. Okay, Mr. Morgan, can you hear me?
Yes, sir. Thank you so much. I'm going to go away from this problem.
Yeah, you're.
I'm sorry. I'm
Mr.
walking
Morgan?
as fast as I can. Yes, sir.
I am going to call your phone number, and I think will probably give us a better connection than what we're getting over the Zoom, okay?
Okay, thank you.
499-3047. Oh, great. You know, I should have written that down. He hung up before I could do that. Shoot. And I don't see any kind of a phone number in the file.
The number you have dialed is not in service.
Well, that wasn't it. Oh, shoot. Oh, here we go.
Hi, sir.
Yes, Mr. Morgan, that's not a whole lot better, but we'll go with that. Sorry.
Can you hear me, sir?
Yes, I can.
Shoo. Sorry, I'm so sorry.
No problem. Okay, so this is Wells Fargo versus Morgan. We're scheduled today, I believe, for a motion for entry of default judgment. Sorry.
Yeah.
Go
I ran into a horribly hard time. I lost both my parents a couple years ago and about 6 months apart, and I just lost all funding to be able to afford that extra house.
All right, so basically what you're telling me is you really don't have a defense other than inability to pay, which unfortunately is not a defense.
Okay. I mean, I don't know. I have no clue how any of this works, sir, and I apologize sincerely for any forthcomings or shortcomings, but I don't know any proper defenses. I don't want this to happen. Unfortunately, it does, but I mean, there is no excuse other than lack of funds.
All right.
Your Honor, if I might just say, this isn't a foreclosure proceeding, just so that it's clear. What happened here is the mortgage was foreclosed upon back in 2008, and then it was rescinded through a payment plan, worked out in 2008. And then what happened is the Court of Appeals came back and said an affidavit is insufficient to rescind a sheriff's sale. And so that's the reason we're here today, is just we're seeking an order effectively doing what we did back when we rescinded that sale. We were looking to have that mortgage reinstated of record, the sheriff's deed rescinded, and Mr. Morgan listed it as the fee simple owner subject to that mortgage. So we're resolving that issue, which is basically a title issue at this point. This isn't a foreclosure proceeding, just to be clear.
Very well. So, Mr. Morgan, I don't know if you heard and understood all of that, but this is actually an action to rescind a foreclosure, which works to your advantage, not to your detriment.
If there is, if there's a current default, that's something where, I could get you a number or something along those lines if you wanted to try and work something out. But I just wanted to be clear that this wasn't any part of a foreclosure proceeding. This is actually just aimed at correcting that, since the Court of Appeals has required a court order versus an affidavit to rescind the sheriff's sale from back in 2009.
Fair enough. Looks like I lost him. Let me try to get him back.
Okay.
Mr. Morgan? Yeah, it was just taking a long time to ring through.
Hello, sir.
Okay, Mr. Morgan, I didn't realize I had lost you. Counsel for the plaintiff just explained to me that what they're asking for is an order from me today rescinding a prior mortgage foreclosure. So what they're asking me to do today actually works to your advantage. It doesn't fix if there's a default in place right now. That's a separate issue. But I'm assuming you're still living in the home?
No, sir, it's an extra home. I cannot afford it. If it were my primary residence, I'd be fighting for my life. It is not. And truthfully, I don't want it anymore. I mean.
All right. Well, that'll have to happen through a different proceeding. All I'm doing today is granting the plaintiff's request to enter an order rescinding a prior foreclosure. In other words, it means the property won't be in foreclosure, but I mean, that doesn't address the other issues. That'll have to happen through a separate action. Okay?
Sure. Can I ask one question while I have you on the phone real quick? Well, so I have not been there to mow the lawn or anything of that nature. It is 100% still my responsibility then.
It's your home until the
Yes.
mortgage gets foreclosed.
Okay. I know that was a dumb question. I just want to make sure. All right. Thank you, sir.
All right. Are you still receiving mail at the 206 East Vandercook Drive address?
No.
How would Ms. And I'm sorry, ma'am, is it pronounced Hack?
Yes.
How could Ms. Hack get a hold of you? Through this phone number that I just dialed?
I received a mail to my current address, 620 Mountie Way.
Could you say that again?
6209 Mountie Way, 49201.
Did you get that, ma'am?
I did. Thank you.
And the phone number that I'm dialing right now, if you want it, is 517-499-3047.
Thank you.
Ms. Hack, you may submit your proposed order, and I will sign it as soon as it comes through.
Okay. Thank you, Your Honor.
You're welcome. That concludes our hearing. Mr. Morgan, you have a good day, sir.
Yeah, sorry for the inconvenience. Thank you.
You're welcome. Bye-bye.
Bye-bye.
Bye.